So if you need a pen or a pencil for that time to come, so you can write that down, just a suggestion. So Lloyd, thank you for being with us, and you've met with Tom and me in the past, and we've been very grateful for your knowledge and your willingness to help us and to help our churches. So we're grateful. I believe you've worked with churches wanting to leave their denomination, all kinds of denominations in something like 25 states, and with some very good success. Is that correct?
Yes, that is correct, Rob. First, let me say thank you for having me. During most of my 37 years in law practice, I've focused on primarily federal constitutional issues, but for the last 15 years, quite unexpectedly, a niche practice in church property law has developed and has been in waves with Episcopalians and then Presbyterians and now Methodists. I've represented churches as small as 20 and as large as 25,000. Some churches that had just a couple $100,000 in assets, some churches that had in excess of $100 million in assets. In more than 25 different states in every section of the country. I want to point out to those that are participating that I've never been an activist in trying to encourage churches to stay in their denomination, or an activist in encouraging churches to leave their denomination. I firmly believe that that is a very sacred decision for local church leaders to make without me trying to push it one way or another. I often can tell a church wonderful news they didn't expect to hear, that there's no enforceable trust against them. But sometimes I have an obligation to tell churches something that they may not want to hear, that there is in fact an enforceable trust that may be irrevocable. But either way, I need to maintain my position as a source of objective, impartial, informed advice. So my role is really to help churches assess risk, to help them understand where they are legally that can inform their negotiations or perhaps litigation if it can't be avoided as they go forward. And I'm often retained to help in those negotiations or litigation. But at the front end, it's for decisions that for the client, the local church to make.
Right.
Lloyd, I think many United Methodists have assumed that their local congregation owns their property and their other assets. And they thought that if they wanted to leave the United Methodist Church to join the Global Methodist Church or some other institution, they could just pull up their tent stakes and head out. But it doesn't work that way because of the trust clause. What a trust clause is and how that impacts United Methodist churches that want to leave their denomination.
Here she is in 2020 yelling.
Yes, there's a lot of confusion about what a trust is. It's not something that you come across very often in everyday life. A trust is an element of ownership. It's not quite the same thing as ownership. It's owning an aspect. It's having an aspect of ownership, the right to control the use of the property, which is different from being the legal owner. A trust beneficiary owns what's called the beneficial interest as opposed to the legal interest. So let me use an example by way of illustration. You may own your home. You bought it. You got a loan from a bank. You've been paying a mortgage for 10, 20, 30 years. Your name is on the title. You are the owner in title and the legal owner of that property. Suppose your homeowners association comes along, however, and amends its articles, its governing documents, to say that you own the property for its benefit, that they have a trust over your property that gives them the right to determine who gets to use or occupy your house. Well, if that were to happen, what would your reaction be? Obviously, you would say, what in the world is that? You have no right to do that. I'm the owner. And under standard trust law in the states, only the owner can grant a trust in favor of another person over their property. So they remain the legal owner, but they may grant a trust interest to a third party. That is why it usually requires action or a writing by the owner rather than some statement or action by the would-be beneficiary. So under normal trust law, a statement in the discipline, a writing by the would-be beneficiary, without more, is insufficient to create an enforceable trust unless the law of that state says otherwise. And there are some states that do say otherwise. But that's what a trust is. It's something that the owner creates on behalf of another that gives a non-owner the beneficial interest to occupy or determine who gets to occupy or use the property.
Lloyd, just to make it clear, who is the owner and when it comes to Methodist churches?
Well, typically the only name in the deed of the local church property is the local church. And if they're incorporated, as they most often are, is the local church corporation. So, and the articles of incorporation typically define the members of the corporation as being the members of the congregation. So the local church is the owner, and the denomination is the purported or would-be beneficiary of the trust. Then the question is, well, is the assertion of a trust in the discipline, a statement by the would-be beneficiary, is that sufficient to create a real trust under the law?
Okay, and so just I'm trying to make certain I understand that other people understand. So if the, really, I believe it's the annual conference, but if the denomination has this, a valid trust, that gives it the right to control what happens on the property?
Yes, that's correct. The local church is still technically the legal owner, but they have, in effect, there's a right by somebody else to determine who gets to use that property. So for all practical purposes, they lose control of the property.
Okay, so unless it's taken to court, the way that it's typically understood, the local church paid for the land, paid for the buildings, kept the upkeep, has done everything to create the buildings and all of the assets. But the annual conference has the rights to control all of those assets should it choose to. Is that close to saying it?
Yeah, yes. If the trust language in the discipline is in fact valid under the law, that would be correct. Here's another example or an illustration that may be helpful to people. Let us suppose that you own an apartment building.
Right.
You're the legal owner. You bought and paid for it. Your name is on the title. Well, you might grant to someone else a right to occupy and use it through a lease.
Yeah.
Now, the fact of a lease doesn't change the fact that you're still the owner.
Okay.
But you've granted to somebody else the right to occupy it and use it for a specified term, the term of a lease. Of course, a trust interest is of an indefinite duration unless it can be revoked.
Okay, so we'll get into whether or not what the United Methodist Church has created as a trust clause is always valid compared to state trust law, because what we're going to find is, I believe, state trust law supersedes in many instances the United Methodist trust clause, which gives some of us hope. So hopefully that's clear to folks that we own the building, but we'll say the United Methodist Church, the annual conference, controls it. And that's why we can't just say, hey, we want to be in a biblical denomination that honors the Bible as God's word and puts Christ first. So we're just getting up and leaving because the trust clause gives the annual conference the ability to prevent that from happening. Now,
well, it purports to.
Yes. Okay. We'll get to that. Thank you, Lloyd, for making making certain we hear that because that's important. So, those of you listening may think, well, why in the world would we ever have set this up? And really, this goes all the way back to John Wesley's time. Tom, you know more about this than most people, more than I do. Why don't you let folks know why we're even dealing with the trust clause? Where did it come from in the first place?
Sure, Rob. As the Methodist movement grew in England and they began to build or buy preaching houses where Methodists served, there was an opportunity for people to decide who they wanted to preach in their preaching house. And Wesley wanted to make sure that the people who preached and pastored in those preaching houses maintained Methodist doctrine. And so beginning in 1763, he developed this model deed that stipulated that there was a trust clause for all of the property that the Methodists had. And this clause was designed to ensure conformity with Wesleyan doctrinal standards. So if there was a dispute, say, between the Methodists and the Calvinists, you could say, well, the Calvinists can't preach here because they're not Methodists in doctrine. And the intent of the conference would be then to award the property to whatever faction was upholding those doctrinal standards of Methodism. The tragic irony that we have today is that those who are not upholding Wesleyan doctrinal standards are the ones that are enforcing the trust clause against we who are intending to uphold those standards. It kind of turns the whole idea of the trust on its head.
Yeah, that is ironic. Wesley put that in place to make certain that his preaching houses were truly Wesleyan. And now that our bishops are in control, they are doing just the opposite. And those of us who want to use our buildings, our assets for what we believe would be very much in line with Wesley are being penalized and being told that we may have our property taken from us. Now, most of you know that we had hoped that General Conference would pass the protocol for separation. And had that passed, it would have allowed churches to leave with their property and their assets and to make no payment to the conference. But because General Conference was delayed and the Global Methodist Church decided because of that delay that it needed to launch, some congregations are wanting to leave right away, but they find that their bishops are requiring that they pay really exorbitant and unfair fees to leave. And so they're wondering if they have any recourse. And when Tom and I met with Lloyd, I was really intrigued to find that at least in some states, and I think really in many, state trust law does supersede church trust law. And if a bishop is being unreasonable, there may very well be a way to leave with your property, your church property, by using the courts. Lloyd, do I have that right?
Yes, that is correct. The courts, civil courts, cannot and should not decide genuinely religious questions, questions whose answers are spiritual in nature. But they do have jurisdiction, authority, to decide property matters, even when the disputes are between religious parties. And there's a long history in the United States, going back to the 1830s, involving churches established in the 1690s, of published court opinions on this issue. And there seems to be a spike about every 30 years, actually. And so some methods have evolved about how courts decide these matters. And there are two basic camps among the 50 states. A minority of states decide what the highest ecclesiastical body that has rendered an opinion on the matter, whether that's a diocese or a conference or a presbytery, has decided, and then they adopt that as the court's own decision. They defer to the higher ecclesiastical authorities. That's the deference method. A handful of states use that. Most states, however, apply the ordinary property law and trust law that would apply to everybody. And so the matter is determined by state corporation law, state property law, and state trust law. And we can talk a little bit later about which states use which, but under the deference method, it really doesn't matter what the local church's facts are, they're going to lose because the denominational authorities never rule against themselves. Under the neutral principles of law method, however, that most states follow, the outcomes can vary depending upon the particular facts of the case as determined by a review of the relevant documents that pertain to property ownership.
So in some states, and we'll get to this, you really have very little chance of being able to take your property and leave if the denomination says no. But in others, you have good reason to believe that you can prevail, even if your bishop and your annual conference says you can't. Correct? We just need to find out where we are.
That is true.
Okay, good deal.
Lloyd, if a church decides to take a legal route, what do they need to do before they approach their bishop if they want to have the greatest chance of overcoming the United Methodist Church's trust clause?
Well, of course, the bishop's authority is pretty substantial. And if a bishop is hostile, he can take some retaliatory action. And so it's important to address these matters very carefully and confidentially. And what a church needs to do is, I think, determine where it stands legally, whether it has a good case or a bad case, a strong case or a weak case, if push were to come to shove and things were to land in court. Now, nobody wants to go to court. Sometimes the church finds itself as a defendant in court, whether they want to or not. Sometimes it's prudent to be proactive and to initiate legal proceedings. But whether you end up in court or not, you're going to be negotiating. Even if you are going through the 2553 process or the 2548.2 process or something else, you're going to be, or settling a lawsuit, you're going to be negotiating. And the strength or weakness of your negotiating position, your bargaining leverage, if you will, to try to get an exorbitant exit fee reduced is a byproduct, a function of the strength or weakness of your legal case. And so there's two things that a church needs to determine. A, what is the law in the state where they're located that would apply? And secondly, what are the facts of their case as determined by a reading with a practice eye of their articles of incorporation and their deeds and other instruments that might indicate intent or the general circumstances, because there are such things as implied trusts that are based under equitable circumstances to avoid unjust enrichment. So you need to know what the law is in your state, whether it's a deference method or a neutral principles of law method, and then have the relevant documents reviewed by someone that knows what to look for to determine what your facts are, whether they're strong or weak. And if you have weak facts, if there's something that could be done to make them stronger.
So Lloyd, to someone like me, this just starts sounding kind of very complex and very overwhelming. But to an attorney, this is kind of just another day at the office, right?
That's very true. Now, this is a very specialized niche. There's not a lot of lawyers that are familiar with this combination of state property and trust law, federal constitutional law, and denominational polity. But at the end of the day, it's a legal dispute like any legal dispute. It's the another day at the office for the attorney. And to make it simple, the 50 states are kind of have segregated themselves into three categories: neutral principles of law states, deference states, and states that have yet to decide, their top court has yet to decide whether they're going to be fish or fowl. And it may be helpful to kind of go through alphabetically which state is which.
Yeah, let's get to that in just a second. I want to go back to this needing an attorney because, like I say, I hear this and it's like, oh my gosh, I don't know if I could ever figure all that out. But when you get the right attorney, you just need to say, here's where we are, and he or she will know how to look at your documents, see if you are in, or if they're in order for having a good outcome, or if some changes need to be made that might give you a better chance. Is that close to right?
Yeah, that's correct. You need your
Okay.
deeds reviewed, your articles of incorporation reviewed
Yep.
to determine if there's trust language in there.
Right.
Because remember, the discipline not only asserts a trust on
Right.
behalf of the denomination, which
Yeah.
by itself isn't valid, but it tells churches they should put trust language in their deeds.
Speaker view.
Yeah.
Mute audio. Stop video.
So, there we go. So,
And
just
many
before we
churches have
move-
done that.
Okay,
And many
just before-
churches have gone ahead and put trust language in their deeds and
Yeah.
in their articles, thinking they're being good Methodists.
right.
And they, in order for there to be a trust, the owner has to put that in writing, and they often have. So then the question becomes, in the law of your state, if there is a trust, can it be rescinded? Can it be revoked? And how you do that.
So just one last thing, and then I'm going to ask you how to find one of these lawyers.
Right on this.
I don't know how to
I
press
can't
every
do
button I can.
anything around my house. Fix a door, fix the plumbing. It is, and I'm not bringing down to what you do to fixing a door, fixing the plumbing. I'm just saying that is too big a project for me. My family knows that I've never asked to do anything around the house because they know I only make it worse. So, but I know I can call the right person. They can come in, they can figure out what the problem is, and they know exactly what to do. And so I'm just hoping that as people hear this, it doesn't sound overwhelming, that what they need to hear is they don't need to understand trust. They don't need to understand neutral principles or hierarchical deference. They really just need to understand that they may have a shot at being able to leave the denomination with their property, and they need to find a good lawyer who can give them good information. So how do you find a good lawyer who might know how to handle these kinds of cases?
Well, that's an excellent question, Rob. What often happens is somebody knows somebody whose brother's a lawyer.
Probably not good, right?
Not good. Or they think property, well, let's get a real estate lawyer. But your typical real estate lawyer is somebody who's closing loans when you're buying a house. That's a horse of a different color. What a church really needs is someone who is familiar with litigation, a litigator, who has some experience in the courtroom, whether it's in trust law or not. And someone who enjoys a reputable, a good reputation locally as ethical and generally competent. There's a national rating service called the Martindale-Hubbell Rating Service. And so you want a lawyer, you want to ask a lawyer if they have an AV rating, which is a top rating for ethics and competency. Bar associations often have a lawyer referral service. I represent churches throughout the United States, but I'm not licensed in every state. So if the matter has to go to court or you have to file something, you get admitted on a specialty basis with an in-state lawyer sponsoring you. And so I work with in-state counsel, for example, all over the country. Now that might sound at first blush like you're doubling your legal costs. But what you're doing is you're tamping them down, because I don't have to learn the nuances of local procedure. Your in-state lawyer knows that. He doesn't have to learn the nuances of church property law. I know that, and the lawyers in my firm who I've tutored and trained know that. And there are some lawyers elsewhere around the country that have some experience in this area as well. But you basically want a litigator who has a local reputation, well thought of by the local judiciary, is ethical and competent, and then they can get the extra advice they need along the way.
So what was it, say again, Lloyd, what was the first resource you gave? for a place you might be able to find?
Well,
someone?
your local bar association often
Okay.
has a lawyer referral service.
Okay.
There is the Martindale Hubble Rating Service.
Okay.
You can ask any lawyer you're considering what their Martindale Hubble rating is. And you
Yeah.
want somebody that has an AV rating. They rate you
Okay.
for both ethics and competency. And so
Okay.
you want someone with the top rating in both.
Good. How much, and I don't know if it makes a difference, big church, little church, or whether the state laws are more in line with what we want, but is there a rule of thumb for how much an attorney is likely to cost?
Well, that's another good question. It's a function of their hourly rate and how much time is involved and
Okay.
what specifically you're asking them to do. Now, hourly rates is a function of your market. Washington, D.C. and New York City is going to charge more than Dubuque, Iowa.
Yeah.
Typically, however, to look at your documents and the articles and the deeds and any other writings and determine what the financial equities are and research your state law and then render an opinion about how that law might apply to your facts.
Right.
Generally, that stage can be done for certainly under $15,000, usually under $5,000.
Okay.
It depends on how complicated the deed record is. For example,
Okay.
some churches bought all their property at once 20 years ago.
Uh-huh.
Other churches are 150 years old and have acquired 60 different tracts over time. It's a function of how many times they've revised their articles of incorporation and so forth. So it's
Okay.
difficult to put a specific number on it.
Okay.
The best range is a range between probably $3,000 and $10,000 for an initial evaluation, typically
Okay.
under 5,000.
Okay, great. And when you begin to compare this to the cost that most churches, when they approach their annual conference and say, how much do I need to pay to get out? That is much less than even what many small churches are being told they need to pay to be able to leave the denomination under 2553. So whether people listening think it's a lot of money or not, it's going to cost a good amount if you just go to your annual conference and say, what's my number? So this might be money very well spent.
Yeah, let me add a word about that because it's important to view whoever you retain, their fees and the expenditure in context. Even if you go to litigation and you're talking $50,000 or $300,000, it's relative to what the value of the property is that you're trying to protect.
Right.
And it's a question of prudent stewardship. If the property is only worth $200,000, it doesn't make sense to spend $50,000 to protect it. If
Right.
it's worth $10 million, it makes sense to spend $100,000 if you have to protect the entire remainder. Another way to look at the fees or the costs is as a percentage of the church's regular operating budget times 3.
Right.
Because typically, if it gets to litigation, it's part of it spans over a
Right.
3-year period typically. And so from that standpoint, what might initially seem expensive becomes a bargain.
Right. Lloyd, you may know, because I sent you this earlier today, and some of you listening will not know about this, but this is very interesting here in Texas. The laws in Texas tend to favor the local church. And there was a small, I say small church, a church of about 100 people. They have on a Sunday morning between 45 and 50. And when they saw how their bishop reacted and other leading pastors reacted in their conference after 2019, condemning the Methodist Church, all the hateful language towards traditionalists, they just decided that they needed to get out. And so they asked their bishop, tell us our number, let's get out. They gave them a number, but they would never write it down. And so they did the things that you have described. They got an attorney, they looked at their deed, they looked at their articles of incorporation, did all of that, made some changes, and then said, we're leaving, and the conference sued them. And just last night, it was announced that the local church had won. That gives us all in Texas great hope that maybe this is beginning to set some kind of precedent. There are other things in Texas that give us hope as well. So I asked him about the expense. So this is a relatively small church. I don't mean to demean other churches if you're one smaller, but their number that they were given was $72,000. That's what the conference gave them. Their legal expenses were $45,000, and now they're going to try to recoup those. So if you think it may be expensive, and we're going to have to pay money, just find out from your annual conference what the cost is for you to leave, because that may shock you. And paying a lawyer $5, $10, $15, if it goes to litigation, $40,000, not only may that let you get out with your property and everything intact, it may be a very good financial deal for you. So Lloyd, if you think this makes sense, let's start talking about, like I say in Texas, we're feeling fairly good, especially after last night. I know it's not a north-south thing. It's not, all of this trust law was written before blue state, red state. I've seen your map. That's not how this breaks down. So how do people begin to figure out, hey, is this even worth doing anything? Do I have a chance? So help us with that, please.
Yeah, let me comment first, though, on a couple of things that you just said about this recent Texas case. Ordinarily, the American rule is that the loser is not required to pay the winner's attorney's fees.
Right.
So that would be a false expectation to have in every instance.
Okay.
Sometimes a court will award attorney's fees that the loser has to pay the winner by way of a sanction. If the court determines that one party has been arbitrary, capricious, proceeded without any rational basis, and so forth. But obtaining sanctions in the form of getting your attorney's fees remitted back to you is an exception, not the rule.
Thank you.
I just want to be, upfront about that.
Thank you.
The other thing is that case that was decided yesterday was really a garden variety application of something that the High Court, the Texas Supreme Court, decided in 2014 in something called the Masterson Case, where the Texas Supreme Court said, we're going to be among those states that use neutral principles of law. We're not going to just defer to the denomination. We're going to apply the ordinary state law of corporations, property, and trusts to determine whether, in fact, a trust really does exist. And so it was a rather straightforward application of that precedent that was established in 2014.
So that decision did not surprise you at all?
Not at all. It was really expected. And of course, it may well be appealed. It's not final. Right. But the trial court proceeded in a very standard way in that case. As I said, Texas decided to join the ranks of states elsewhere in the country that use neutral principles. The U.S. Supreme Court has said that states are free to decide these matters in any way that states see fit, provided that they don't decide it on the basis of some religious question or the court's opinion of what right doctrine is, and so forth. And so over the years, two methods have been developed. The deference method that I explained before, and there are about 10 states throughout the United States that apply the deference method, where local churches really are facing a very challenging legal environment. I'll put it that way.
Are you going to tell us which ones they are?
Yes,
oh,
they
gosh,
are.
I'm going to watch as our numbers just drop off as people get this bad news. Hold on, guys. God bless you.
There are two states that say that they follow neutral principles of law, but when they go through state law, they come across a unique statute in that state that in effect converts that state to the deference method. So both California and Georgia are nominally neutral principles, but in reality, de facto are deference states. In addition, Florida, Michigan, Nevada, New Jersey, possibly North Carolina, I'm not certain, Oklahoma, the state of Washington, and West Virginia are deference states. Now, there's a dozen states that are neither deference states or neutral principles of law states. There's just not been an occasion yet for their state Supreme Court to decide this issue. And so it's a blank slate, really. There may be some lower court decisions in one appellate jurisdiction going one way, another appellate jurisdiction in another, but there's no real statewide method yet. And there's 12 states that fall into the undecided category. That would be Arizona, Hawaii, Idaho, possibly Kansas. I need to look at that more closely. Nebraska, New Mexico, North Dakota, Rhode Island, Tennessee, Utah, Vermont, and Wyoming. Now, Tennessee is an interesting example. Tennessee has, I think, at least 3 different courts of appeal: Eastern Tennessee, Central Tennessee, Western Tennessee, and they all follow different methods. And the state Supreme Court hasn't really set a statewide standard. So there's 12 states that statewide are undecided, but there's over half the states follow neutral principles of law. They say that the bishop can decide religious questions, but as to who has a right to control the property, that's determined by our state's corporation, property, and trust law. And those states are, and there's actually 3 subsets of neutral principles. That may be getting down into the weeds a little bit more, but there's some variations within the neutral principles of camp. But the states that have adopted some form of neutral principles are Alabama, Alaska, Arkansas, Colorado. I'm doing this alphabetically if you haven't picked up on that.
Thank you.
Connecticut, Delaware, Indiana, Kentucky, Louisiana, Maine, Maryland, Massachusetts, Minnesota, Mississippi, Missouri, Montana, New Hampshire, New York, Ohio, Oregon, Pennsylvania, South Carolina, South Dakota, Texas, Virginia, and Wisconsin. Now, of the states that follow, that don't just say, we're going to do whatever the diocese or the conference of the presbytery say, we're going to apply our standard state law to the facts of the case as determined by a review of the deeds and the articles and so forth. There's a couple of important variations within the neutral principles camp. Some neutral principles states are very strict about it. They follow a strict form of neutral principles where they cross the T's and dot the I's very carefully in terms of what the deeds and what the articles say and so forth. Some neutral principle states are called hybrid states. They frankly can be a little mushy and at times ambiguous. And they follow neutral principles, which include looking at the denominational constitution, because you have to have mutual intent. And obviously, if the denominational constitution isn't asserting a trust to begin with, that's relevant, or if they condition it on certain factors. But some states can put a disproportionate amount of weight on the denominational constitution, kind of a thumb on the scale, if you wish. And it involves a very specific examination of that state court's jurisprudence and the particular language in its decisions, because some states are kind of part fish and part fowl. They fall into the neutral principles camp but in a hybrid sort of a way rather than a strict way. The strict states, let me just list what those are. It's a subset of that list of states I just gave. The strict neutral principle states would include Alabama, Indiana, Kentucky, Louisiana, Minnesota, Mississippi, Missouri, New Hampshire, New York, Ohio, Oregon, Pennsylvania, South Carolina, South Dakota, and Texas. Those are the subset within the larger list of neutral principle states that where the outcomes can be most predictable.
So if you're in one of those, you feel very good about your chances. And if you're in the other two subcategories, you still have a good shot.
Assuming that your facts are good.
Right. And that's but when you say that, Lloyd, to make certain I understand, that means looking at your deeds, your articles of incorporation, make certain those are state, and you can go in and change those, correct? So that your quote facts are better for you by the time that you begin this process. Is that correct?
Yes, you have to have those ducks lined up in a row before litigation, because the court's going to take the facts as they existed before a lawsuit was filed.
But just because they're not where they should be now doesn't mean you have to live with that. You can go and change those before you begin the litigation process.
Absolutely. That's what
Okay.
that church in Texas that you alluded to a
Yeah.
few moments ago did. That's what
Yeah.
SMU did a year or so ago. And so that's, in fact, in the Masterson case, the Texas Supreme Court case in 2014, that's what that church did. Now, a bishop his reach may extend to removing a pastor or changing the composition of the administrative council, but the bishop cannot reach to change or affect the composition of your corporation's board of directors.
Okay.
And they would have the authority, and the members of the corporation would have the authority to vote to amend their articles if they needed to, in order to clean up their language without interference by the denominational authorities.
Let me ask one more question, then I know Tom has a question that he wants to ask. So sometimes I tell people just because you could doesn't mean you should. So there may be times when a church could win their case, but they shouldn't try because it's going to be very upsetting for their congregation, or the cost may be more than if they approach their bishop kind of amicably. And if they have a bishop who really is trying to help, Lloyd, you may or may not know, we have some bishops who are willing to follow what has been stated and to be gracious. We have others, believe it or not, are saying, yeah, you have to pay 2 years of apportionments, you have to pay your unfunded pension liability. And one bishop is saying, and 50% of all your assets. And another saying 25% of all your assets. This is being punitive. This is bishops that have lectured us for decades about having a heart of peace. And can't we all stay at the table and get along? And now we discover that rather than having a heart of peace, they want their piece of flesh from people that just want to go do what God has called them to do. That's not all of them. We have some good ones, and we're grateful for those. But when would you recommend to a church, and maybe I'm not trying to keep somebody from getting with a lawyer, I want them to do what makes sense for them, just like how you started. But when would you be likely to say, hey, we could win this thing, but maybe it's best not to pursue this legally. It's best just to go to our bishop amicably and say, can't we work this out, and try to do that? Do you have some principles or guidelines for that?
Well, litigation is always, in my view anyway, a remedy of last resort. Sometimes you can't help it. Sometimes the conference gives you no choice. Sometimes the conference makes you a defendant.
Yeah.
If the cost of litigation is disproportionate to the value of the property, obviously it makes no sense to litigate. If the financial terms a conference is offering are modest, reasonable, doable, it makes sense to go through that path rather than to litigate. I will tell you that with several hundred Presbyterian examples from your Calvinist brothers and sisters that have gone through this over the last 10 years. The average percentage of net asset value that the counterparts to the conferences, the presbyteries, would demand in exchange for relinquishing the denomination's claim of a trust was usually around 5% of a church's net asset value. And that was put on a promissory note with a 3-year payout oftentimes. So to demand a 25% or 50%, I'm aware of one circumstance where it was 60%, is a conference really looking for a windfall if they've never invested into the purchase of the property to begin with, or the building on that land, or insuring it, or maintaining it, and so forth. And that is why, if the protocols ever pass, they would be a very welcome glide path financially, because they do not include a property equity fee. They just require a true up of the apportionments plus a couple of years to kind of help with the transition, some pro rata share of a conference's unfunded pension liability, which is reasonable, assuming it's rationally calculated, but no exorbitant property fee demand. So if your conference has taken a position to maybe only require a certain amount of apportionments or a pension amount to avoid a problem there, and is not insisting on a property equity fee, that can be a very good financial deal and should be looked at very carefully. Unfortunately, while some conferences have taken that position, many haven't.
Yeah, thank you. Tom?
So just kind of piggybacking on what you've been talking about lately, Lloyd, if a church finds itself in a deference state, should they just assume that there's nothing that can be done, and whatever the conference demands of them is what they're going to have to do, and there's no point even hiring an attorney or even considering any kind of legal process?
Well, once a deference state, not always a deference state, state Supreme Courts, if a state Supreme Court has adopted the deference method back in the 40s or 50s or 60s or 70s and hasn't looked at it since then, the world really changed with the US Supreme Court decision in 1979. And almost every state that has decided this matter for the first time since 1979 has adopted the neutral principles of law method. So in a state that is a deference state for a long, long time, the church has to be prepared to lose at the trial court level and the Court of Appeal level, because they're required to follow the decisions of their state Supreme Court. But if the state Supreme Court decides to hear the case on appeal, grant cert, as lawyers call it, the law could change. But again, regardless of what the law is, depending upon the personalities involved, there's going to be some negotiations, even in a deference state, depending upon what the bishop is going to require and so forth. And your bargaining position in those negotiations, and the conference's bargaining position in those negotiations, is going to be determined by each's perception of how strong or weak their own case is legally, and how strong or weak the other side's case is. So regardless, I think it's always prudent, regardless of what state you're in, to get a grip on what your state law is and what your facts are, to get a lawyer who knows what they're doing, to look at your articles and look at your deeds, and then let you know where you stand and if your position can be improved.
Good, Lloyd.
And very helpful. So maybe we should have started with this question, but I'll close with a philosophical question, and then hopefully we'll have some time to get to some of the questions people have submitted through the chat. But Paul tells the Christians in 1 Corinthians not to go to court to work out their grievances. So how can we feel good about going to court to overturn the trust clause? And how do we make sense of that in terms of our willingness to follow Scripture?
Well, that is a fantastic question. My faith is very important. And in good conscience, I couldn't do something that I know might violate some command of Scripture. Paul did encourage believers to try to settle their differences quietly among themselves without going public and elevating unbelieving judges over the saints. And in light of that Pauline advice, some had concluded, perhaps prematurely, that it's always wrong for Christians to seek the protection or remedy afforded by civil courts. But the whole counsel of God isn't quite as black and white as that. Paul himself invoked his civil rights as a Roman citizen when he appealed to Caesar in response to attacks against him by religious authorities that were in effect attacks against the gospel. And Paul's admonition against using government courts wasn't because there was anything inherently evil in government courts, but because of corrupt human motives that often accompany lawsuits. So we need to check our hearts and make sure that we are proceeding with proper motives. Here in the United States, our court system may be secular, but it's not pagan. It's founded on Judeo-Christian principles, one of which is equal justice under law before an impartial tribunal, which means a decision maker that doesn't have a financial interest in the outcome. And unfortunately, that isn't the case if the matter is resolved internally within the denomination's own decision-making system. So I think it's important too to remember a couple things also, that the kind of disputes in civil court over church property are of a fundamentally different nature than the kind of lawsuits that Paul was talking about. Paul was talking about disputes between believers where one was trying to vindicate some personal offense or wrong that they suffered. But in these church property cases, typically the parties are corporations, civil creatures, the church corporation and the conference, which is a human construct. And the board of trustees of a corporation aren't trying to vindicate their own personal rights. They have a fiduciary duty, a legal obligation to protect the rights of others, the members of the church corporation or the congregation. So amicable discussions always to be preferred, but I think we need to be on guard against a false piety that would disparage all efforts to seek the remedies that might be afforded by the civil law. As Methodists, it's interesting or relevant to know what the discipline says about this. And the discipline says that while the church is of God, it lives within the context of civil society. And therefore, it has to account for its property as a matter of civil accountability. Paragraphs 141 and 163 of the discipline is something that folks might want to read later when they go offline. The discipline says this, quote, the ministry of the UMC exists in the secular world and that civil authorities may seek legal definition, socially and culturally conditioned ownership of property, therefore is to be considered a responsibility to God. And we therefore believe that governments, this is the discipline saying this, that governments have the responsibility in the pursuit of justice and order under law to provide procedures that protect the rights of the whole society as well as those of private ownership.
Wow.
End quote. So the discipline says that as Methodists, we live in civil society and that government has the right to establish procedures in the administration of justice to resolve disputes about private ownership.
Lloyd, that's very helpful. I appreciate it. Look, we've gotten a bunch of questions. Tom, let me ask this one, then you, while I'm talking with Lloyd, look at what you think might be a good next one, and we'll take the next 10 or 15 minutes to answer these. And I tell you what, let me do this, because some of you may start feeling a need to, as the hour comes to a close. Some of you are going to want to stay on very much. Others of you may need to leave. So Lloyd has been very good about making himself available. So I'm going to give you his email address, and then I'm going to give you how you can contact us at Good News. So if you have a question we don't get to, and Lloyd, you're kind of trying to cut down on your hours, right? I'm afraid I'm going to make that impossible for you here right now. But you can reach him at email. I'm going to spell this out for you. It's Lloyd, Lloyd dot Lunceford, Lunceford at Taylor, Taylor, Porter, Porter.com. So Lloyd with 2 L's, Lloyd.Lunceford at taylorporter.com. And if you need help from Good News, we're not going to be able to do the legal part for you. We can maybe answer some questions you might have about the discipline, and we can maybe help you if you're in a church that's divided, know how to present the issues that are dividing us, which are much more than just our differences regarding sexuality. That's the tip of the iceberg of the presenting problem, but we have so many differences about how we see the Bible, about who Jesus is, about how we make theological and moral decisions. I don't say this with any joy, and I'm not trying to be hyperbolic. We're just two different tribes, and we just need to say, hey, we don't need to beat each other up anymore. Let's set each other to be free. And your church is very likely not to understand just how liberal and progressive many of our bishops have become, many of our pastors, many of our annual conference board of ministries has become, and we can help you with that. So if you have a question for Good News, send it to info@goodnewsmag.org. So info@goodnewsmag.org. So Lloyd, here's a first question. Tom, if you'll see another. We have some folks who are asking us, hey, if would it make sense for a bunch of our churches to go together and talk with a lawyer, and then maybe approach the annual conference that way? It's interesting, Lloyd, at this WCA meeting that we were just at, 107 churches in Florida announced that they were in the process of disaffiliating. They had gotten together, they'd worked together, they had strong leadership in their conference. And one of them told me they had gotten a lawyer for all of them. And so whenever someone from the conference office contacted them, they said, thank you for your call, you'll need to speak to our lawyer. And it just meant they were not going to be embroiled with daily questions, or but they were not going to be intimidated regularly. It's like, no, this is a legal matter now, so you need to talk with our lawyer. But they felt like it was beneficial to have one lawyer who was handling all of those churches' concerns. Does that have some advantage to doing it that way?
Well, it's interesting that your example is Florida.
Right.
Florida is a state where the individual facts from church to church don't matter.
Okay.
Because it's a deference state. And so all you're really left with is researching the state law to find that out, if you don't know that already. And then engaging in negotiations. And so if they're leaving collectively, there are strength in numbers. And there may be some negotiating leverage to be had by pooling their resources with an individual spokesperson, a single attorney. Most states, the facts do matter in neutral principles of law states. And so it's a church by church, case by case, particularized evaluation. And so a class action suit for example, is off the table. And so you couldn't have one lawsuit with, 160 plaintiffs in it. Now, that may appear to be a practical problem, but it's a good thing that the facts matter,
Yeah.
that the denomination doesn't always win. But regardless of the state, neutral principles or deference method, there can be some cost savings, some economies of scale where legal costs can be shared for those matters that all the churches would have in common. So if you need to have the state law researched to find out what the law is in Tennessee or Iowa or whatever, that's going to apply to any church, one lawyer can research that for one church client or 40 church clients, and the 40 church clients can share those costs. But evaluating whether an individual church has a strong or a weak case under that law, if it's neutral principles, is a church by church analysis, where each church needs to have its own, and a church may hire the same lawyer, but if the matter goes into litigation or negotiations, it's a one at a time, individualized process.
Okay, thank you. Tom?
So Lloyd, this is a basic question. Does the trust cover just physical property like building and land, or does it also include other assets that the church might have?
Well, the Methodist Trust Clause reads differently than its Episcopalian and Presbyterian counterparts. In the Presbyterian Book of Order, as it's called, and in the Episcopal canons, the trust says that it applies to all property, real and personal, movable and immovable, buildings and the equipment inside of it, and vehicles owned by the church, and bank accounts and so forth, and that are held by or for the particular church. So if there's assets owned by a freestanding foundation or an endowment fund, and the articles of that endowment fund say it's to be used for the church, the text of the Presbyterian and Episcopal trust clauses very plainly reach to encompass that or purport to do so. The Methodist Trust Clause is a little more ambiguous. It tends to talk about meeting houses and parsonages, but the Trust Clause itself, in paragraph 2501, says all properties of United Methodist local churches and other Methodist agencies are held in trust. And so it's not limited to just real property. It's a little broader and ambiguous. And most conferences have taken the view that if they're requiring a percentage of net asset value, in addition to an apportionment payment, and in addition to some pro rata share of unfunded pension liability, they're also demanding some percentage of net asset value as a property fee. In determining that, they're going to factor in not just the real estate, but the endowment fund, the bank accounts, and so forth. Now, some churches have, a lot of churches have cemeteries with separate cemetery associations that are or not incorporated. And most conferences tend to take that off the table and don't include that in their calculations.
Great.
Lloyd, let me ask this. There are several people have said they didn't hear you mention Illinois, and they're just concerned about that. Where does that state fall, if you have that with you?
That was an inadvertent oversight. Illinois is a neutral principles of law state.
Okay.
What about
Good.
Iowa? We had a request about Iowa as well.
You know, these states are not just flyover states, Lloyd. They really matter.
That's right. Well, I hope we don't have trouble in River City.
Oh, I think we do have trouble in River City, brother. We got trouble everywhere.
That
I tell folks who's ever been praying that we Methodists may live in interesting times, they can stop praying because they got us there, and I can't take it any more interesting than it is right now.
Yeah. Iowa is a hybrid state, a neutral principle state, but
Okay.
kind of one of the mushy ones.
All right. Tom, this is more of a question for you, and then maybe we'll just take one or two more. There are a lot of good ones. I wish we could get to all of them. There are a few people who've typed in, well, look, why don't we just wait for 2024 for the protocol to pass, and then, you know, we'll have this uniform procedure that's very fair. Why don't we just wait till then? Your thoughts, Tom?
Well, certainly for some annual conferences and local church situations, it makes sense to wait because they can't get out right now and without paying an exorbitant fee. And we understand that. The passage of the protocol in 2020 was just about guaranteed. I mean, we had full support from across the spectrum theologically, and people were ready to pass it. In the 2 years that have intervened, that support has grown a bit more lukewarm, and we have even some who have signed the protocol in the beginning have kind of pulled back on their support of it. Some of the bishops that signed it are among the bishops that are now charging exorbitant property fees. So that support has waned, and in the next 2 years, who knows what's going to happen, whether that support will continue to wane or whether it will grow. And we also don't know the composition of the delegation for 2024, whether, I mean, if a number of evangelical leaders leave in their particular annual conferences, they may not be elected to general conference delegates. And so we may weaken ourselves. And so it really depends on whether, to pass the protocol is dependent on whether the centrists and progressives are willing to support it. And I think that's kind of a risky bet at this point.
Yeah, if I may, and this is, we're just being honest with you at this point. And if this is cynical, I'd love to think this is cynical rather than being correct. But Tom and I have been dealing with people on the other side of things for decades now. And we have had to act as if we had good faith partners, because the only way to create an agreement where we could move out together was to have good faith partners that wanted to stop the fighting and wanted to find a way to bless each other and say, we set you free to pursue what you think God wants you to do. And if God blesses you, great. And if he doesn't, well, that's up to God. But what we have come to believe is that we really don't have good faith partners anymore. Tom, I don't mean to be speaking for you, but over and over again, agreements that people on the other side have made with us, they then walk away from. They explain why they can no longer honor their agreements to work together with us. And so we have no confidence whatsoever that those who agreed to the protocol when it was passed, we thought a wonderful thing that God had done to bring people together from every major special interest group, progressive, centrist, traditional. It was miraculous that we all agreed together. And now we've watched as they've walked away from it, and they began to signal that they were not going to support it. And if you are holding on to the hope that after more and more evangelicals and more international African delegates have left, and the progressives have gained even a greater upper hand, if you're holding on to the idea that at that point, they will be as gracious to you as they would have been under the protocol, I hope you're right, but I think you're naive. And like Tom said, some churches, they cannot get out. We have a brother in Colorado, and the number he's being given for his church is so high, they don't see how they could ever pay it. And real estate is so high, they can't leave and ever go someplace else. They really feel stuck. So they don't they're looking at their options. They don't have much they can do except hold on and hope that something is made better. But if you can get a good deal, either by doing the kinds of things that we talked about tonight, or by approaching your bishop and hoping and praying before you go that he or she will be very amicable and will have a kingdom mindset rather than a punitive mindset or institutionalist mindset. If you can get a good deal now, we really think that is your best bet. And by the way, the Global Methodist Church is there waiting for you. It's going to be a wonderful movement of God, and I think you'll be blessed the quicker you get to it. Tom,
Rob,
if you want to, yeah, Lloyd.
if I could just piggyback for a moment on something you've said. The protocols, if passed, would have been some new provisions in the discipline. Right now, there are some existing provisions in the discipline that establish a national exit process that were adopted in 2019, paragraph 2553.
Yep.
But in 2553 has 5 or 6 different steps involved, the last of which is a vote by your annual conference, which meets annually. The ones that I'm familiar with tend to meet in May or April. So if you miss that window,
May or June, yeah.
I'm sorry, May or June, you got to, get lined up to have a vote in May or June of 2023. But paragraph 2553 is kind of term limited. It expires if all the steps are not completed by the end of 2023, by December 31st of 2023.
Yeah.
So in the absence of the protocols and the absence of litigation, if you're going to negotiate your way out in a non-litigation way, it's still good to know what your legal position is, strong or weak. But if you're going to go through the 2553 process, it is available. It's multi-stepped. It usually requires 3 or 4 months to jump through all the hoops, and does require a vote by a body that only meets once a year.
Yep. Thank you, Lloyd. So the deal is, don't just put this off. If you think you want to do something, begin it. Even if you don't know everything it's going to be required, or just take the next step. And that's probably finding a good attorney who can begin advising you. So here's what I think we need to do, and that is, if you have our info at goodnewsmag.org, and if you have a question that you really need to have answered and we haven't gotten to it, first of all, I'm sorry, send that in to us. And if Tom or I can answer it, we will. If we need to ask Lloyd's expertise, we'll do that, and we'll try to get back to you. Some of you are asking if we'll put a list of the states on our website. I believe we'll be able to do that and try to give you some information that way. Again, this has been recorded, and you can point this out to friends so that they will be able to do it. Tom, do you know how they are going to be able to see this in a future date?
We're going to post it on our YouTube channel, and we will, as one of our perspectives, we'll let you know that link so that you can go to it. So we'll have that available, and probably post something on our website as well to direct.
Okay, what is our YouTube channel?
Good question. Good news.
You would think the two of us would know. Look, if you have not.
There's usually a search function on YouTube.
Yeah.
And if you type good news, your videos will pop up.
Yeah, it may be Good News or Good News Mag. There's several Good News, but you'll see us on there. And the other thing to do is, if you do not get our weekly what's called perspective, 90% of the time it's Tom writing a very insightful article. Send something to info@goodnewsmag.org saying, I'd like to start receiving the perspective. And so when we send out a link to this, you can get it. That way you can share it with others in your church or friends at other places. So Tom or Lloyd, anything else we need to say before we close up?
I just want to thank you for having me.
Yep.
And I'm in the business of practicing law. I've got some junior partners that I've trained to carry the load, where I function more now these days in a consultative capacity. But I'm certainly not the only game in town. There's others very competent counsel around the country.
Good.
And in other states, I work with in-state counsel. So I am open for business and glad to help.
Good. Thank you. We really appreciate you, Lloyd. I appreciate you approaching us years ago, just saying I may have some things that could help you in the churches you care about. And we were so impressed when you did, and have always been very appreciative. Tom, do you have anything to say?
No, many of the questions that came in were more specific to the situation of
Right.
a particular state or conference, or and also there were questions about 2553 and the exit process and all that. And so we may end up having another webinar that deals directly just with that aspect of it.
Okay, good.
That's something that we're going to look at.
All right. Hey, Lloyd, why don't you hold on just a little bit and we'll let others take off. God bless you all. Hey, here's the main thing. Let's keep doing good work in our churches for the kingdom of God, for the glory of Jesus, for lost people who need to come to real faith in Christ. Let's don't get bitter. Let's don't be angry people. Let's be happy warriors who know that there's a good day ahead for us. And let's keep it classy for Jesus. Okay. God bless you guys. Thanks. We'll be in touch.